So please give him a warm welcome to the Howard Student Body President, Jaden Cody.
Thank you so much, Jennifer. First of all, good morning, everybody. My name is Jaden Alexander Cody. I am a third-year law student here. I'm a graduating third-year law student. I got to throw that in now. From the best city in the world, Atlanta, Georgia, and I have the privilege and pleasure of serving this great institution as the 70th Student Bar Association president, student body president of the law school. I just want to say before I do what I have to do for Dean, Professor Ifill, I have to honor you, I have to thank you, I have to say I am immensely proud to be able to call you professor. Even if you did not do what you are doing at Howard University, you would still be an icon in our community, in our practice. And as all great monuments, you said, I'm not gonna stop. I'm going to continue, and so we honor you for that. This institution has always had a through line between the rights of people and the people that we equip to be attorneys. And you are just exposing that just a bit more. So I know on behalf of the alums who are proud of you, who are proud of what you are doing, they are excited to see what this center does. The current students who have asked to come to this institution because of the great work like our alums do, they are excited to walk with you and partner with you in that work. And the students who are deciding, even some today, to come to this great institution, you're making their decision even easier. So I just want to say thank you. Thank you for, even in the midst of saying I'm going to take a step back, answering the call again and continuing your purpose in illuminating this great work. We are very appreciative of you. Yes, 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 yes. Now, what I was actually asked to do, our great Dean, Dean Roger Fairfax, is going to come and welcome you all to this great symposium. So everyone give a round of applause for Dean Roger Fairfax.
Good morning. Thank you, Jaden, for introducing me. Reverend Lamar, I know Reverend Lamar's in there. You got an associate pastor here, you know, after he finishes the bar exam. So I want to welcome you all to the Howard University School of Law. As was mentioned, my name is Roger Fairfax, and I am honored to be servant leader of this storied institution. And we are thrilled to have you all here for the 14th Amendment Center on Law and Democracy, the inaugural symposium, Reimagining American Democracy, the 14th Amendment. Let's give it up again for Professor. Now, you are in for an extraordinary day of programming. For those who were unable to be with us at yesterday evening's launch reception, you missed a master class on the often ignored meaning and promise of the 14th Amendment. Now, Sherrilyn Ifill wears many hats, as we all know, but that professor hat was squarely on her head last night as she illuminated the legislative history of the 14th Amendment and what motivated those founders, and yes, they were founders, to adopt those 425 words across 5 sections that not only amended a constitution, but reimagined a nation. An amendment that did so much beyond that familiar first section. An amendment that gave Congress the power and indeed the moral responsibility to act, to implement its protections. A call that would go unanswered by our national legislature from 1875 until the late 1950s. And we at the Howard University School of Law are thrilled to host this extraordinary interdisciplinary center. Indeed, we are an institution founded on a January 6th which our nation can be proud of. January 6th, 1869, just 181 days after the ratification of the 14th Amendment. And Howard Law alumni and faculty giants such as Charles Hamilton Houston and Thurgood Marshall and Oliver Hill and Pauli Murray and Spotswood Robinson and James Nabrett and Dovey Johnson Roundtree and George E.C. Hayes and Robert Carter and Gabrielle Kirk McDonald have been some of the fiercest defenders of the promise of the 14th Amendment over the past 156 years. And as I mentioned at yesterday evening's reception, today's symposium will be engaging the work, the opportunities, the challenges, and the charge that each and every one of us, individuals and entities, must take up in the weeks and months and years to come. The sessions to come will explore many of the organizing themes of the center's work, including in law and policy, education and curriculum, art, narrative, and imagination, and democratic institutions. So prepare for a day of robust engagement reflecting the brilliance of the many participants on this unbelievable agenda. And before we begin, I have to say a few words about the thought leader, the force of nature, who has brought this vision to fruition. As the immediate past leader of the nation's premier civil rights legal organization, Sherrilyn Ifill is an heir to the legacy of Charles Hamilton Houston and Thurgood Marshall and Constance Baker Motley and Jack Greenberg and Elaine Jones and others who led LDF's struggle for civil rights and equal justice. She began her career as a fellow at the American Civil Liberties Union before joining the staff of LDF, where she litigated voting rights cases. She then left LDF to join the faculty at the University of Maryland Law School, spent over 2 decades there teaching civil procedure and constitutional law to thousands of law students, and pioneered a series of innovative legal clinics focused on criminal justice, environmental justice, and racial justice. She is also a prolific scholar who has published academic articles in leading law journals and op-eds and commentaries in leading newspapers and on her very popular Substack. Her book, On the Courthouse Lawn, Confronting the Legacy of Lynching in the 21st Century, was highly acclaimed and is credited for laying the foundation for contemporary conversations about lynching and reconciliation. And I believe she's actually testifying next week before the Maryland Lynching Truth and Reconciliation Commission. She is currently completing a book about race in the current crisis in American democracy entitled, Is This America?, which will be published by Penguin Press. And as the 7th president and director counsel at LDF, from 2013 until 2022, Sherrilyn played a prominent role in shaping our national conversation about race and civil rights. She led LDF in groundbreaking litigation in the areas of voting rights, economic justice, education, and took a prominent role in confronting police violence against unarmed Black people. She raised the profile of LDF, growing the organization in staff, in resources, and in influence. She's the recipient of numerous honorary doctorates, including from New York University, American University, Bard College, and the Fordham Law School. She's also received prestigious awards such as the Radcliffe Medal, the Brandeis Medal, and the American Bar Association's Thurgood Marshall Award. She has been inducted into the American Academy of Arts and Sciences and has been named by both Time Magazine and Glamour Magazine as one of their Women of the Year. She also has been named Attorney of the Year by American Lawyer Magazine and by Time Magazine as one of the 100 most influential people in the world. She serves on the board of the Mellon Foundation, the Baltimore Museum of Art, and the Board of Trustees of the NYU Law School, and as a senior fellow of the Ford Foundation. And she even served on President Biden's commission on the Supreme Court. But most importantly, from my perspective as Dean of the Howard University School of Law, She is the inaugural holder of the Vernon L. Jordan Jr. Endowed Chair in Civil Rights at the Howard University School of Law. And before she graduated from Vassar College and NYU School of Law, this daughter of Queens, New York, attended Hillcrest High School, which boasts a list of famous alumni, as I've learned. Fran Dresser, the nanny, is a graduate of Hillcrest. Ray Romano, everybody loves Raymond, Hillcrest High School. Well, I don't know if everybody loves Raymond, but I know we all love Sherrilyn Ifill. Please join me in welcoming Sherrilyn Ifill.
Thank you. Thank you all so much. Yes, that's where I get my theatrical chops from, is Hillcrest High School. I'll be able to see you all. Good morning, everyone. Thank you so much for being here. Thank you so much, Dean Fairfax. It means so much to me to hear that introduction. And to be here at Howard, I just have loved the experience of being here, love our students, love the faculty, love the warmth that's here, love the sense of purpose. And Howard is not a perfect place by any stretch of the imagination, but the people are unbelievable. And so I thank you all, and it's made my transition from LDF easier because I feel like I'm in the same line of work, working for our people, which makes me very happy. I'm not gonna do a lot of thanks and acknowledgement because what I have learned is that last night my little lecture that was supposed to be 20 minutes actually was over an hour. We don't have that kind of time because we want to get to this first panel. But I do feel the need to say to you something about the 14th Amendment just to lay the foundation for the day so everybody's on the same page. Now, those who were here for the seminar last night, don't be calling out answers because you already had the seminar last night. Y'all just be quiet and let me just do this thing. So I'm going to try to truncate it so that everybody just kind of has the same information. Now, if I ask you, and again, people who were here last night, shh. Judge Wynn, Judge Reeves, you weren't here last night, but shh. Call out some of the names of the founders of our country. Call out names. Hamilton, come on, you gotta know that. Who else? Phyllis Wheatley. Who else? John Jay. Washington. Madison. Adams. Jefferson. Come on. These are cheating. These are the cheating people over here. Okay. The reason I ask that question is because the answers that we normally give are Washington and Jefferson and Jay and Hamilton. But those answers belie the truth about our founding, which is that we've had more than one founding, that we had a second founding after the Civil War, that when our country was torn apart by war, and that war was completed, and there were 600,000 people dead, the country had to be stitched back together. And that is our refounding. And the core pieces, the thread that stitched the country back together, were created and drafted as 3 amendments to our Constitution, which we call the Civil War Amendments or the Reconstruction Amendments, the 13th, 14th, and 15th Amendments to our Constitution. The 13th Amendment you know about because the 13th Amendment abolished slavery. The 15th Amendment did not create a right to vote, but it did remove the possibility that you could legally deny the vote based on race. Now, we know the vote has been denied based on race, but I said legally, right? That constitutionally, you are supposed to be prohibited from denying the ability of people to vote based on race. But the core, the center, is the 14th Amendment. And the 14th Amendment is the amendment that was called by one of its drafters the blueprint for a new nation. The blueprint for a new nation. Now, that's a pretty big deal. And it's kind of interesting that we don't know very much about the 14th Amendment or its founders. So I want us to think about first where we were at the moment of founding. I want us to go back to 1866, when the Civil War is now kind of over. By the way, they were still fighting battles of the Civil War all through the drafting of the 14th Amendment. We think about the Civil War ending at Appomattox with that handshake, but there were battles still being fought in Texas and Oklahoma. The war was still, there were skirmishes still happening. So I say all this to talk about the challenge that faced the people who had to do this. And those people decided that they had to set about and create this important amendment. Now, we've got, at this moment as well, 4 million Black people who now are free, right, because we've ratified the 13th Amendment. And the question now is, how do we ensure that those people can be citizens? And so the 14th Amendment first sets about trying to establish the citizenship of Black people, the full and fair and free citizenship of Black people, and has to figure out how to put this all together in a way that it will have sticking power. Now, do they just go in a room and just start drafting stuff up? No, they do not. They actually do some study. They actually send emissaries to the South to understand what was happening in the South. In fact, President Andrew Johnson, who's a villain of this period, this was the vice president of President Lincoln, he sends an emissary south. He sends one of his good friends south. And he sends his good friend because he believes that the South should just be brought back into the Union. We don't need loyalty tests. The war is over. Everything's fine now. And so he wants his friend to come back and give that report, that everything's fine in the South. But his friend, a German national named Karl Schurz, comes back, and the report is quite startling. The report is about what are the conditions in the South. And Karl Schurz finds a number of things, but two things that he finds that are significant. One is he finds that there is an enduring spirit of insurrection in the South among white people. And he says they hardly seem to think that it's a problem to be treasonous. They have no allegiance, he says, to the national government. In fact, they're only going along because, for the most part, they just want their power back. They want to be readmitted to the Union, and they want to have their power to rule over their states. And the second thing he finds is the enduring power of white supremacy. He finds that essentially most in the South are working to return Black people to a condition of servitude without the official moniker of slavery. He talks in particular about the insistence of white people on whipping Black people and the belief that Black people cannot work without physical compulsion. And so he comes back with a report that is not the report Andrew Johnson was expecting, and it's worrisome. Meanwhile, the Joint Committee on Reconstruction is also having their own experience trying to understand what the conditions are. They are confronted with the fact that former Confederate leaders, including 4 Confederate generals and the Vice President of the Confederacy, arrive here in Washington, D.C. and say, we have been sent by our states, we would like to be seated in the United States Senate. And the radical Republicans who are in the Congress say, no, you were just fighting against the nation. You can't just come in and take a seat in the United States Senate. We have to have some sense of your loyalty, your renunciation of secession, and your commitment to the Union. So they are very disturbed also. They're seeing the spirit of insurrection that is stubborn. And so they set about deciding how they are going to cope with this reality, and what they create is the 14th Amendment. Now, the 14th Amendment is so important because it does something that no other amendments to our Constitution do, which is that they are able to marry soaring promise, that is the promise of our nation, which is really displayed in Section 1 of the 14th Amendment. And I don't know if we have that slide of Section 1. Section 1 is the part that most law students, lawyers, judges are familiar with, and most Americans are, even if they don't know it's Section 1 of the 14th Amendment. But to the extent you think that you are entitled to equality or equal treatment, that word shows up first in the 14th Amendment. It's not even in our first Constitution. So it is the first section that includes the first line, all persons born or naturalized in the United States are citizens of the United States and of the state in which they reside, which we call birthright citizenship. That's the first line of the 14th Amendment, in case you were wondering where that came from, right? It promises due process of laws. It says that the privileges and immunities of citizenship cannot be abridged, and promises equal protection of laws. And so our whole national identity, the identity that's premised on the fact that if you know that no matter where your parents are from, or no matter if you were born in another country, if you have a child, your child is American, that came from the 14th Amendment. That didn't just come from the air. That didn't come from Madison, Jay, Jefferson, Washington. Didn't come from any of them. If you think you're entitled to equality, that also wasn't in the first Constitution. If you think it was, the reason you think it was is because you're thinking about the Declaration of Independence. You're thinking about, we hold these truths to be self-evident, that all men are created equal and are entitled to life, liberty, and the pursuit of happiness. That's the Declaration of Independence. That's not the first Constitution. First Constitution says that for purposes of representation, black people are counted as 3/5 of a person. First Constitution says that the slave trade can continue until 1808. That's what those framers did. The second framers do this. They decide that there is birthright citizenship, that there is equal protection of laws, that there is due process. Now, why do they have to start with birthright citizenship? Because the Dred Scott case, which I'm sure many of you have heard of, right? The case that was called the opening salvo in the Civil War, is the case in which the United States Supreme Court said that black people could not be citizens. Not enslaved black people, all black people. So even if you were free and you lived in New York, you now no longer had national citizenship after Dred Scott. So the first thing they had to do was ensure the citizenship of black people, and that is where we get birthright citizenship from. And it's an important innovation. Not every country had it, right? You were French because your parents were French. You were German because your father was German and your grandfather was German. But in America, we adopted the idea that the soil made you a citizen if you weren't naturalized. And that's important. That's an important part of our legacy. So when you hear it bandied about, for years we've heard, we're going to get rid of birthright citizenship. Okay, it's in the Constitution. It's in the 14th Amendment. It's not a policy choice that anyone has made. And we're going to hear lots of litigation about it in the coming weeks. But that's the source of it. And in case you're wondering whether they anticipated the issue of migrants and birthright citizenship, you should know that those very framers scuffled around issues of their own prejudices. In this case, the people they were most prejudiced against, at least some of them, were the Chinese. The Chinese were not even allowed to be citizens of this country at that time. But they were concerned, some of them, that the children of Chinese laborers would now be American if they were born here. And they explicitly asked those questions. Shall we be overrun by the children of Chinese laborers in California? And they had those debates, and then they came to adopt birthright citizenship and said, yes, we will accept that even the children of Chinese labor. So in case you're thinking, well, they weren't anticipating that we might have migrants and that there might be other people that we don't want, they too had their own prejudices. This is nothing new under the sun. But they came to the conclusion that they would adopt birthright citizenship. So we have all of this that's jam-packed in Section 1, but there are 5 sections of the 14th Amendment, which the dean already alluded to, and I just want to quickly hit the highlights of a couple of them. When I was in law school, I learned about the 14th Amendment, and we read 2 sections. We read Section 1 and we read Section 5, which we'll come to in a minute. But there's Section 2. Let's see if we can go to Section 2. There it is. Section 2, you can't read all those words, but Section 2 basically is a punishment regime because of the very issues that I described to you earlier. There was the belief that that the southern states would never allow black men to vote without some push. And the push they decided on was not to create a right to vote, and this really pissed off Frederick Douglass. What they decided was to create a punishment regime, which essentially says that states that deny the right to vote to black men over age 21, remember at this time, women don't have the right to vote, and 18-year-olds don't have the right to vote. But those states that deny the right to vote to black men, to essentially what they meant was black men, over the age of 21, will have their congressional representation reduced by the amount of eligible voters they disenfranchise. Now, I love the Voting Rights Act. I love it. But there's also this that is in the 14th Amendment that has never been activated. That is reducing the representation of states that engage in voter suppression and disenfranchisement. They put that in because they knew. Section 3 you may have heard something about because there was kind of a big case last year. Section 3 is the section that says that if you participate in insurrection, you cannot serve in federal or state office. And I can guarantee you that most of the judges who were deciding those cases had never read Section 3 of the 14th Amendment before, because I didn't learn it in law school either. Remember, I told you the two things they were concerned about, the spirit of insurrection and white supremacy. And so Section 2 and Section 3, we see them attempting to deal with that. And they didn't think it would be a passing thing, or else you wouldn't put it in the Constitution. You just do a statute. But to put it in the Constitution, they wanted it to exist, to not be able to be overturned by successive Congresses. And I mentioned last night what Frederick Douglass said about why he thought black people should have the right to vote in the 14th Amendment. He was pissed about this because he thought we needed an affirmative right to vote in the 14th Amendment. And the reason he said was because black people needed to be able to protect themselves politically in the South. And he said, and I'm quoting, "The spirit of the traitor," he said, "will be passed from sire to son. It will not end in a year, it will not end in an age." And so we see Sections 2 and Section 3. Section 4 is about the public debt after war, and it may actually have some good connections to our debt ceiling, but we're not going to talk about that today. And Section 5 is the other one because it's really important. Section 5 is the enforcement clause. Who do they give the power to enforce all the guarantees of this amendment? Do they give it to the states? Do they give it to the president? Do they give it to the Supreme Court? They give it to Congress. Congress has the power to enforce the provisions of the 14th Amendment, which means when Congress doesn't act to protect the rights that are articulated in the 14th Amendment, they're not doing their job. They don't give the right to states because the 14th Amendment and all of the Civil War amendments, 13th, 14th, and 15th, express the view that the states cannot be trusted to protect certain rights. And that's why these amendments use words like "no state shall." It is a rebuke because we have learned through this process that although the first Constitution was designed to protect us against the infringements of the federal government, we needed protections against infringements of the state government. And that's what the 14th Amendment is about. Now, this is chock full. This is, I mean, maybe you're not getting it, but you will by the end of today. This is serious stuff. This is reordering the relationship of power between the state and the federal government. This is putting your federal citizenship first. Go back to Section 1 again. Every person born in the United States, born or naturalized in the United States, shall be a, 1, citizen of the United States, 2, and of the state in which they reside. Putting your U.S., your national citizenship, ahead of your state citizenship. You know, the folks in the first Constitution, all the folks you were calling out, you know, they were Virginians and New Yorkers and Pennsylvanians. Your state citizenship was really important to your identity. But the 14th Amendment is telling you that what comes first? Your national citizenship. So they're reordering citizenship, they're reordering power, and it's a big deal. Why don't you know all these things about the 14th Amendment? Because it was subverted and disempowered almost before it had a chance to breathe. And by 30 years after its ratification, black people are confined mostly to sharecropping and domestic work, do not have rights to travel where they will, do not have rights to live where they will, cannot vote. All of the things that these amendments were enacted and ratified to alleviate now had returned. Why did that happen? 1, the Supreme Court. We can talk maybe about the 4 cases that the Supreme Court decided, beginning in 1875 with the Slaughterhouse case and ending with the case you all are familiar with, 1896, Plessy versus Ferguson. That's Homer Plessy there, which brought us Jim Crow segregation as constitutional law, according to the Supreme Court at that time. And that is how we lived for at least the next 60 years. There was also violence. Violence in the South, the Colfax Massacre, the Memphis Massacre, the Wilmington, North Carolina massacre, the Elaine, Arkansas massacre, and of course, the ongoing presence of lynching and later police violence. That slide is from my first experience of police violence against an unarmed African American. That was in Queens. The boy was 10, I was 10, which is why the story was so resonant for me, Clifford Glover. All of these things together conspired to take away the power of the 14th Amendment and, of course, congressional inaction. From the Civil Rights Act of 1875, which the Supreme Court struck down in the 1880s, Congress did not enact a civil rights statute until the Civil Rights Act of 1957. So for all of those years, Congress could have passed a Civil Rights Act of 1964 anytime during this period. They could have passed a Voting Rights Act. They could have passed a Fair Housing Act. None of that happened in this period, and they refused to pass anti-lynching legislation. So the Supreme Court, violence, inaction by Congress all conspired to bring us to the point where so many of us do not know about this rich history and the rich protections that are in the 14th Amendment. The people who revived the 14th Amendment were civil rights activists. First, the lawyers, that's Charles Hamilton Houston, Constance Baker Motley, and Arthur Shores, who's a local attorney in Alabama. That's Wiley Branton, another former dean of this law school, and who's next to him? I can't see. Thurgood Marshall. The lawyers, beginning their strategy in 1935 and then bringing it up to Brown in 1954, were fighting to restore the 14th Amendment. But so too were the activists. So too was Fannie Lou Hamer and the lunch counter sit-ins and Martin Luther King and the Selma marchers. Do we talk about the civil rights movement as a 14th Amendment movement? Do we talk about it as a constitutional movement, or do we just talk about it as a grassroots movement in which people were trying to get people to feel something for the oppression of Black people? Part of why I'm creating this center is to move us away from that, is to demand that we talk about the right to equality in constitutional terms. I began this journey, as I have told many people, because it worries me and concerns me how we have allowed the conversation about race and rights to become one about feelings and morality rather than the Constitution. Most of us know, and when I say us, I mean most Americans, feel very comfortable talking about their First Amendment rights. Now, very often they are wrong. They are wrong, and so they'll say it's my First Amendment right when they're on a privately run, privately owned social media platform. The First Amendment is designed to protect you against government intrusion on your speech. But in any case, people feel very comfortable saying, it's my First Amendment right if someone tries to stop you from speaking or stop you from exercising your religion. You believe that you have that First Amendment right. People very casually say, I plead the Fifth, because we know that the Fifth Amendment has the right against self-incrimination. And if you see someone in a fast food restaurant with an AR-15 or a rifle on his back, and you feel courageous enough to approach that person, and you ask them, why do you have that rifle on your back if you're just getting a burger and fries? They will say, because it's my Second Amendment right. So everybody's talking about their rights in terms of the Constitution, and then we're talking about prejudice and bias and discrimination. Even as a civil rights lawyer, I don't walk around and talk about my 14th Amendment rights. We don't ground it in the Constitution, and so we give away its power. I'm not asking you to be nice to me. It doesn't matter to me whether you have a racist bone in your body. It doesn't matter to me whether you see race. It doesn't matter to me whether you are colorblind. All of those things are about feelings, morality, emotions. What matters to me is whether you are respecting the rights that I hold under the United States Constitution. So the point of the center is to inculcate that in us. Begins with lawyers and judges, but all of us. We don't need a lawyer to tell us that we have First Amendment rights or that we have Second Amendment rights. We feel very comfortable saying that as ordinary Americans. I want ordinary Americans to feel comfortable about their 14th Amendment rights and to give them the due to which they are entitled. You've heard already Dean Fairfax talk about the 4 sections of work that we'll do in the center: law and policy, education and curriculum, art, narrative and imagination, and democratic institutions. And we'll talk about that more as the day rolls on. The purpose of today is for you to begin to see the kind of work that we might do in the center. So if you're thinking you're going to go away today and you're going to have it all, you're not going to have it all. I'm giving you a taste of the conversations, the convening, the strategic conversations that we might have going forward, the collaborations that we might build going forward, so that you can have a sense of the kind of work we're going to do in the center. We are not a litigation shop. I very much enjoyed my time as a litigator. That's not going to be my thing, at least not my primary work anymore. Sure, we will file amicus briefs in important cases. We did last year in the insurrection case, in the Section 3 case. We will likely in the birthright citizenship case. And so we will support the strategy of lawyers. We will support the policy initiatives that may arise, absolutely, but we will not ourselves be taking on our own litigation. We will lean into the narrative work. The very stories that I'm telling you that no one seems to know about are stories that have to become part of what we know, especially at a time when we are restricting the kind of education that young people are getting and grown people are getting. And I want us to do that work through this center, not only here in the law school, but out in community so that people can have access to this information. We want to forge collaborations with artists, which we're already beginning to do, who I really believe can help free us up to imagine and envision the kind of democracy that we want. Imagination is the tool of artists, and we need access to that tool, and we need to work with them. And you'll hear about that later today when we have a panel and when we have a conversation with filmmaker Ava DuVernay. And we're going to work with institutional leaders in journalism, tech, business, and faith leaders, Reverend Lamar. These are all institutions of democracy, civic institutions, and they have responsibilities too. Not just individual citizens to get out and vote, but journalists have responsibilities. Business has responsibilities. How many of you know that in the first 60 years after the 14th Amendment was ratified, that it was used more to protect corporate rights than to protect the rights of Black people? You know that. Why? Because corporations, in fact, one of the drafters of the 14th Amendment was essentially a corporate lawyer and had in his mind right from the beginning that we're going to figure out how corporations can get attached to this. And remember, corporations are state entities. You are a corporation, you're incorporated in New York, you're incorporated in California, you're incorporated in Delaware. So you are a state entity. And the Supreme Court decided in the 1880s that corporations are persons for purposes of the 14th Amendment. And that's why you can have cases like Citizens United, or you can have the Supreme Court decide in the Hobby Lobby case, that sound familiar, that corporations have rights to religious freedom. So corporations use the 14th Amendment. And my question to corporations, therefore, is, and what do you give? Saying you're a job creator ain't it. You have to line up with the 14th Amendment. You have to line up with the principles of equality. You have to line up with the principles of due process. You have to line up with this amendment that gives you power and gives you benefits. So we're going to be engaging in those collaborations to smoke out our civic institutions and compel them to come to the table as well. All of this we're going to do with this conceit in mind, explicitly, which is that the center is one where we can focus on imagining a better, stronger, healthier democracy. My goal is to help us get out ahead of the current moment and to bring strategic visioning to our future. It comes so fast, and we must, those of us who litigate in this space and who do civil rights work and who care about equality and justice, we have to reserve some of our time, some of our energy, some of our working, and our strategic thinking to focus on the future, on what comes next. And this center is explicitly designed to open and power up our democratic imagination to focus on building the country we dream of. The idea is for us to see ourselves as founders and framers of a new iteration of our democracy. And the reason why it's important, our first panel is so important, see the segue? Is because the truth of the 14th Amendment is that founders and framers, I had you all shout out names, and indeed John Bingham and Thaddeus Stevens and Charles Sumner, these are all radical Republicans who helped draft the 14th Amendment, but they are not the only founders. The founding and framing of the 14th Amendment happened over decades. It was free Black people in the North, including Black sailors, who you'll hear Martha Jones talk about, who were fighting for their freedom and citizenship, getting on a boat in New York, getting off in South Carolina, and being taken off the boat and placed in prison, right? It was the suffragists. It was the other free Black people who were fighting for their rights. It was the colored conventions who were meeting together and petitioning. And if you go into the legislative history of the 14th Amendment, you'll see the petitions of the colored conventions describing what they believe citizenship meant. And all of that is important, especially in this moment, because I want you to believe that nothing is wasted. Not George Floyd protests, not the kind of strategic thinking and reset that many of us had to do in COVID, not our voting rights protests, not our reproductive rights protests and writing, not our amicus briefs. All of the work that we do, which you maybe can't see at this moment, is part of the founding and framing of the next iteration.